prospective suit.
So a prisoner whose religious rights are being violated has been disciplined for a violation of his or her religious rights can't come into court and say, this regulation is unconstitutional because it will impinge on religious rights. I want you prospectively to enjoin this regulation. A prisoner can't do that?
I think the question there would be, has he been disciplined and suffered a loss of good time credits such that
Let's assume that. Assume it.
If he has, then yes, we do understand.
What sense does that make?
And what difference does it make? I mean, what if he says, I'm not challenging, or I don't really care about what has happened to me in the past. I'm saying from this point forward, this is unconstitutional, and please do not allow it to happen to me again.
So at the outset, I'll say, of course, the court doesn't need to resolve this question because the petitioner here is out of custody. But the sense that we think that this line makes is that the court has been very concerned about allowing an end run around the federal habeas statute. And of course, anything that might imply that the deprivation of—
So why did we do Edwards, which was written by Justice Scalia? Edwards was a disciplinary hearing with the loss of good time credit. And Justice Scalia dismissed all of the retrospective claims, money damages, declaratory judgment, but he permitted the prospective challenge of whether the disciplinary procedures were unconstitutional. He remanded it to see if they could move forward. And he said there's a difference between retrospective relief and prospective relief.
That's right, and I want to be clear that a prospective challenge ordinarily will not necessarily imply the invalidity of a past deprivation.
But your argument
of good time
today would have
credits.
made Edwards dismiss the whole case, not part of it.
I don't think so, because I think the court was clear that a prospective challenge to the unconstitutionality of procedures won't necessarily imply the invalidity of past deprivations of good time credits. There's a difference there between a a challenge to procedures prospectively, which we absolutely agree under Edwards can go forward, and the rare case where a prospective challenge would necessarily imply the invalidity of the conviction, but a facial challenge to the constitutionality of the rule that the individual in custody violated might be that type of prospective suit. So
that's exactly what this case is about.
Right. So for us, it is critical that the individual is out of custody.
But I'm saying to you, I don't think it should make a difference whether he or she is in custody, and I don't see that our cases have ever, whether it's Edwards or Wilkinson or any other, has focused in on that as the exclusive remedy.
I think
as the exclusive situation.
If you think that a prospective suit could proceed in or out of custody, that makes this case all the easier. And of course, the court doesn't need to address whether someone in custody can bring this type of suit. We're just trying to reserve the question because we do think it would implicate different and more difficult questions.
Well,